Jail, good afternoon. My name's John Hurley. I'm your judge this afternoon. We're in first appearance court. Today is the day the court determines whether or not there's probable cause for your arrest. We're not here for a trial. We are not here to determine whether you're guilty or not guilty. That's not for today. The reason I'm telling you that is you do not need to tell us about your case. You don't need to tell us what did or did not happen. Those matters are best saved for your attorney in a private meeting. Don't air them out here in open court. Everything's being recorded, and if you say something that the prosecutor deems to be incriminating, I can assure you he will get a copy of this video and play it for your judge or jury at a later date. Now, if you have a private attorney when you're called up, let me know who that is, and we'll try to reach out to your attorney and let them know that you're in court. Also, when I call out your name, step forward. As soon as we're done with your case, just step off to the side. And I have Judge Kim Malika, kind of a new judge, and she's going to be doing first appearance here in a short amount of time. So she's going to be sitting next to me, and we're going to try to work on this en banc. Have you ever had an en banc, sir, for first appearance? Well, if you haven't, today's the first day. All right? We have our senior attorney, Mr. Reedy, here in court today.
Good afternoon, Judge.
Always a pleasure, sir.
Judges.
Yeah, always a pleasure. State?
Yes,
All
sir.
right. So here we go. So, all right, here
Don't
we
forget
go.
Mr. Romero, Judge.
Oh, Mr. Romero, it's good to see you again. Sorry about that. Well, when I said senior lawyers, I didn't include you in that, Mr. Romero. So,
I appreciate that.
okay, no problem. All right, Alazia Buford, are you here? Alazia, please step forward.
She's approaching. She declined the services. Okay.
Hello, ma'am.
Hi.
Ms. Buford, count 1, false ID given to the police. Count 2, possession of cannabis. 3, license suspended. 4 and 5 are traffic tickets. Count 6 is a probation violation. That's out of Orange County. That's a no bond hold. Ma'am, today I'm going to go ahead and give you a bond on count 1 of $1,000 and count 3, $750. Good luck, ma'am. Thank you. Okay. May I see Elizabeth Roche?
She's here at me. She's approaching.
Hello, Ms. Roche. Ma'am, burglary of a conveyance and drug paraphernalia. The court finds probable cause to both counts. State, does she have a criminal record?
I believe pre-trial has some information for the court.
Your Honor, she's currently being supervised by pretrial services for case number 1700.
Judge, we can't hear pre-trial.
Okay.
She's being supervised by pre-trial under case number 177346 CF10A.
Okay. So she's already out on the cocaine charge. She's picked up this, but they didn't put it on her. So, okay. Any prior state?
2015 unlawful use of false name ID and trespass. 2015 trespass.
Got it. And, all right, I'm going to go ahead and set her bond. I think it's kind of academic at this point. Ma'am, it's alleged that you burglarized a vehicle where the owner of the vehicle was in a vehicle next to you and watched the whole thing happen. So it's a very strong case at this point. The court's going to set your bond on count 1 at $5,000. Count 2, the court's going to set that at $1,000. Your total new bonds today are $6,000 based on the strength of the case, the facts of the case, and your criminal record. The court will also revoke the bond you're out on, the release you're out on, case 17007346 CF10A. That'll be a no bond hold, and you'll have to go see your trial judge, ma'am. Thank you. Just gonna stand. There you go.
Unless you don't
Okay.
slide here.
May I see Anthony Pete? Anthony Pete?
He's in North Broward, Judge.
Okay, North Broward is right there. These are new controls since they updated it. All right. Hey, Mr. Pete, how you doing? Mr. Pete, you've been charged with a battery, and the court does find probable cause. State, does this gentleman have a criminal record?
Yes, Your Honor. He pled a trespass out about just under 2 weeks ago. Loitering and prowling early August. Felony theft 2015, theft 2015, Felony battery due to priors in 2014. He
Felony
violated
battery, what year was that?
2014, Your Honor.
2014, got
Yes,
it.
he violated his probation, was sentenced to 364 days in county jail. Trespass 2013.
Got it.
It goes a lot of thefts. It goes on from there.
Got it. Okay. All right, sir, do you have anything you want to add, Mr. Reedy, or do you want me to just question the defendant as to his ties?
I'd rather you didn't do either. I have nothing to add. I tried to communicate with Mr. Pete, had a great deal of difficulty in that area, so I have really nothing to add at this point.
Okay,
And Your Honor, I'm sorry. One other prior, and I'm only bringing this to the court's attention because I believe in the past, when it was your division, you asked me, you wanted to be made aware. 2001, 2 counts of lewd and lascivious conduct in front of a child less than 16.
2001, lewd and lascivious.
And that was a direct file.
Okay.
He was charged as an adult.
Got it. Okay, sir, I could go ahead and set your bond and release conditions. If you want to tell me about your ties to the community, how long you lived here, I'll let you tell me about it, or you can just not say anything. Okay, I'll accept your silence. Sir, I do look, you allegedly were groping women here in Broward County outside of a nightclub. 3 women, I believe. They all told the police that you were grabbing them on their backside. I do note you've been convicted twice of lewd and lascivious and once of a felony battery. So you do have violence in the past, so plus recent theft, loitering and prowling. I'm going to raise your bond today, sir, to $7,500 and allow you to bond out. I'm going to ask you not to come within 500 feet of Club Euro. Thank you. Okay, how about George Madrano?
Mr. Madrano, come on up, please.
In jail?
Your Honor?
Yeah, I got a driving record.
Your Honor?
Yeah, I'm sorry.
I'm sorry, in the last case, of abundance of caution, did the court order no victim contact?
No, I didn't do that. I think it was so random, he didn't even know who the person was.
Okay.
So, there you go,
Yeah,
sorry.
no, they did, that is true.
Right there. Okay,
Matter of fact, could you write in there no?
let's see here, driving record.
500 feet of-
Right here.
or
This should be
incident location,
Madrano,
whatever.
close to the top. Yeah, right here. You could toss that in the garbage. We already did that case. There you go. All right, are you Mr. Madrano?
Good morning, Your Honor.
Hi, how are you doing, Mr. Madrano?
I'm doing better.
Okay. Mr. Madrano, you're here for operating with no driver's license, and the court does find probable cause. I reviewed your driving record, sir. I think that goes in there somewhere. I've reviewed your driving record. You do have a driving record. It shows you have no license, but I do see that without a driver's license, you've been convicted of DUI. You've had multiple traffic tickets. You actually have been arrested on 2 DUIs with no driver's license. 2 times. You've been convicted of obtaining a driver's license by fraud in 2016. And you've been caught driving with no license in the past. So go ahead. Anything the defense would like to say?
Judge, the only thing I believe his the DUI you were referring to might have been about 2 years ago.
Well, there's 2 DUIs. There was one from 2001, and there was one from 2015.
2 years ago, correct, the last one.
Right.
He lives in Hollywood with his wife. He's been married now for about 22 years. I advised him, is there any way your wife could go ahead and post the bond, or why hasn't she posted the $25 bond? He advised me that right now she can't afford to post bond. He has other people that he may be able to contact, but it's in his phone, so I'd be asking you to sign a phone order allowing him to get his phone contact so he can see if he can contact anybody else to post his bond. Judge, considering at this time he's been residing in Hollywood for 22 years, strong ties community, I'd ask you at this time just to leave the standard bond in place.
Yes, sir. Anything you want to say about release conditions or ability to make bond or anything else? Is that it? Okay.
At this time, yes.
State.
Your Honor, just to advise the court, while it was a 2015 DUI, he just got off probation July of this year. Actually, you signed his VOP warrant.
Right.
His probation was revoked, and just looking at the warrant, what it was alleged, that He didn't complete DUI school.
Right.
He failed to submit urinalysis test.
Well, the court's concerned because this gentleman appears to have never had a driver's license. He's got 2 DUI arrests, at least 1 conviction. He's never had a driver's license
Well,
that I could see. And he continues to drive. In this case we're here on, he was driving about midnight. So clearly he, after 2 DUIs, it appears this gentleman doesn't realize he's not supposed to be operating a motor vehicle. Frankly, sir, the court thinks you're a danger to the community. You've had 2 DUIs, you have no license, and the court can imagine you don't even have automobile insurance. So I'm going to set your bond at $5,000 in order. You are not allowed to operate a motor vehicle under any circumstance while you're out on release. Thank you, sir. Can you throw that away? Now see Paul Charette.
Judge, and you'll sign the phone order?
Yes, sir.
Thank you.
They asked if you'll sign. Hey, how are you? Can I have the driving records? Do you see Paul Charette in there? Paul Charette. See this? Hey, Mr. Charette, you're charged with license suspended. Give me just a quick moment. Let me just take this. Wow. Okay. The court does find probable cause. State, do you have any priors?
Your Honor, do you have anything since 01? What's that half file for?
Anything by the defense they'd like to share with us?
What was the deal?
Judge, yes, we'd be asking for pretrial. I know he was interviewed by pretrial. He informed me that he's 56 years old. He's been living in our community since 1986. He's currently working for a company called Ed Koch Drywall Services. He's been working for them since 1999. His boss allows him to reside at the warehouse. That's where he resides. He actually has a mailing address, which is located in Fort Lauderdale. That's where he gets all his important papers that he needs to receive. Judge, we'd be asking you at this time to consider placing Mr. Charette on pretrial release. My understanding is the last time he was arrested was probably 2001.
Right.
Judge, he has no way of posting any sort of monetary bond.
I understand. Sir, I'm going to go ahead and I'm going to set your bond today at $7,500. You're driving on a permanent DUI revocation. You have been convicted of DUI 1, 2, 3, 4 times. You're under a 10-year revocation, a 5-year revocation, a 6-month revocation, and a permanent revocation. Here, you're allegedly driving late in the evening, and you allegedly ran a stoplight at Broward Boulevard 995. So it appears that you're not abiding by your DUI permanent license revocation. The court's concerned for the safety of the community. Your bond is going to be $7,500. You can bond out, but while you're out on bond, you're absolutely not allowed to operate a motor vehicle. Thank you. Here you go. Okay. May I see Robert Lee? Robert Lee.
We waive formal reading of the charges, Your Honor.
Understand. Mr. Robert Lee, the court has found probable cause on 4 very serious, well, before we get to that, there are 4 very serious charges in front of the court at this time. Now, I'm going to advise you, you have the right to remain silent. If you give up the right to remain silent today and you make any comment regarding your arrest or what led up to you being arrested, whatever you say can and will be used against you. Everything is being recorded. Do you understand what I've explained, Mr. Lee?
Yes, sir.
Okay, Mr. Lee, do you have a private attorney?
Yes, I do.
What is that attorney's name?
Joseph Fazone?
Joe Fazone?
Yes.
Does he know you're in custody right now?
Yes.
Okay. Well, would you like me to reach out and contact him, or does he know you're going to be in court? Are you expecting him to come to this hearing?
No, sir. I didn't expect him to. I'm not 100% sure of his knowledge of where I'm at or what I'm doing.
Would you like me to proceed with the hearing?
I would like for you to contact him first.
Okay, stand by one moment.
Yes, sir.
Okay, let me see how I do this. Mute, right here? Is that off?
I think so.
Yeah, but it still says speakers are on. What did we do?
Did not speakers, didn't hit that.
Then hit what? This?
This, speakers are on, hit it again.
There, good. Okay, do you know Fazan's
Well,
number?
if you don't mind,
Call
I'm.
him? Okay. Nobody can hear us.
Hi, may I please speak with Joseph Fasone? Hey, it's Eric Linder at the State Attorney's Office. Eric Linder at the State Attorney's Office. Hey, good, how are you? We got a Robert Lee here at first appearances. Are you representing him?
Eric got a hold of him.
I'll tell the judge. Mr. Lee has advised us that he would like his case reset.
Yeah, could you be here?
So he can contact Mr. Fasone.
He's at the phone with him.
Brian, I'm on the phone with him.
Oh, okay. Mr. Lee,
Could you,
don't know
could you? Well, if it's okay with the judge, could you be here? Yeah. Hold on 1 second. You're okay if he has jeans on, correct? It's Judge Hurley. He's fine with that. No. I mean, I'm just. It's so we're in 4155 in the new courthouse. About how long would you need? Yeah. Okay, I'll let him know. Okay, thank you. All right, bye. Mr. Frazone will be here in about 20 minutes.
Take that off. Okay. Mr. Robert Lee, just stand by. Just have a seat. Your attorney's going to be here in about 20 minutes, all right?
Yes, sir.
Okay. Just put it at the sidebar, stand by. Okay, what about Aaron Troy?
He bonded, Your Honor.
Okay, Troy bonded. I'm going to find PC. It's academic at this stage. He's bonded. I just read BND. There you go. Okay, Eric Skoglund. Eric
I've
Skoglund.
been advised, medical reset.
All right, got it. State, do you want me to address probable cause now, or do you want to?
No, I'm fine with it
Okay,
tomorrow.
so I'll just reset. I'm not going to sign or do anything. Just let me put on here, Med Saturday. Med Sat. There you go. So tomorrow, there you go. All right, what about Jameel Warner? Jameel Warner?
North Broad, Your Honor.
Okay, North Broward. Hey, Mr. Warner, how you doing?
How you doing?
Good.
Okay, sir.
Mr. Warner, you're charged with burglary of a dwelling, and it appears that this is a refile, and so it was originally Berg occupied?
He was arrested for burglary of an occupied dwelling, Your Honor. The state filed burglary of a dwelling, I guess you could call it unoccupied. It's still a second-degree felony, and that's why I provided the court with a copy of the probable cause affidavit. As you can see, this wasn't a situation where it was a misbook or a misbook where it should have been filed as a burglary of an unoccupied dwelling. There clearly was a victim home. The state just, case filers will file this as unoccupied since they're both second degrees, they don't have to prove the extra element.
Sure.
But as far as the facts or the aggravating factors, it is clear that there was, based on the probable cause affidavit, the resident was home. As you can see, bond was originally set at $5,000. He's also being held no bond on a capias for a grand theft. So I'm just asking that the court reset the $5,000 bond.
Okay, any objection by the defense?
In light of the fact that Mr. Warner has a no bond hold, he's going to have to go in front of his division judge
Okay.
to resolve these matters anyway.
Mr. Warner, I'm just going to put your bond back as the way it was before, and you can go to your trial judge and work it out, all right? Good luck, sir.
Yes, sir.
Thank you.
Yes, sir. Thank you.
Yes, sir. That's what it was the first time I got arrested. Just leave it there. You know, this
You
may go
have
with
one
it if
case
you want.
on the docket that you did not call.
Who's that?
Gerard Hamlet.
I've got it right here. Do you have Hamlet?
just here approaching, Judge. He's here at Maine.
You have Hamlet in Maine? Thank you.
Correct.
All right. Just- Okay, possession of heroin and cannabis, and the court finds probable cause. Mr. Hamlet, Steve, do we have any criminal record on this gentleman?
Your Honor, Mr. Hamlet was arrested August 2nd of this year and was released on bond August 3rd for fleeing and eluding law enforcement at a high rate of speed and misdemeanor possession of cannabis.
Okay.
He also has priors, I believe, out of the state of California. Our pretrial worker advised the court. I don't know if pretrial still has those.
He has priors out of California and the state of Illinois.
Okay.
Would you like me to read it for
Sure,
the
go ahead.
record? Out
What-
of the state of California, 2013, taking a vehicle without consent, 2014 trespassing, 2014 another misdemeanor trespassing. Out of Illinois, 2008 battery and bodily harm, 2008 he had a warrant for battery and bodily harm, and 2008 possession of cannabis.
Okay. Got it. All right, and what's the case number on the case he's out on right now?
Case number is 179062 CF10A.
Okay. Any comment by the defense as far as bond goes today?
Judge, as far as, we'd be asking you at this time to keep the standard bond in place as far as the new charge. In reference to some of the priors that I think we heard, being recited, by pretrial, I know Mr. Hamlet, is advising me on some of them, they were actually dropped, so I don't think they were convictions. But having said that, Judge, I believe the case in which he's currently out on bond, 179062 CF10A, my understanding is that this time it's still unfiled. I'd ask you at this time not to take any action. The state attorney in that division certainly could go ahead and do a motion to revoke bond at a later date. So we'd be asking you not to take any action, leave the standard bond in place, Judge.
Yes, sir. So I'm going to go ahead today. I'm going to set your bond at $1,000 on the case you're out on, revoke your bond or release on 179062 CF10A. You're going to be held without bond until further order of the court, and the court also takes into consideration your criminal record of the state of California and the state of Illinois. State, will you give me an order to that effect,
Yes,
revoking
Judge.
that release? Thank you. Now, how about, okay, we put that off. What else do we have on our docket?
We've got a few second looks and 2 motions to release.
Okay. Do I go online for the second looks?
I know some. Are you able to get onto the computer there? I know
Yeah.
some judges haven't been
I'm
able to.
gonna give it a shot.
All right.
We're in experimental territory right here. Let's see here. Okay. See what I'm doing?
Bless you.
Doing your access, huh?
Okay, other user. Okay, let's see here. Okay, so let's see here, view calendar. So how do I get into,
That's the problem because there's no division.
oh yeah,
Just
so,
hit find a case. Do you have the
Here.
case number?
no, I think it's actually gonna give me this. So it's popping up right here. I think it's
She wouldn't
going,
have to worry about that if she was weekend, so.
this is. I can't figure this out.
Well, I think,
You would just call it,
confinement, if you wanna see the reports, I believe, does confinement status have the reports?
Yes.
And if any other questions, I
just in
can,
case I held a guy no bond on. Okay, so, do you wanna give me the
I
cases?
can have them lined up over here, Judge.
well,
I just don't know what,
do you have the docket, Judge?
I have a docket.
Okay.
Is Kathy Akins one of the people on it?
Yes.
North
Okay.
Broward.
North Broward, Kathy Akins. Right there. No, that's okay, we don't need it. Hey there, oh, thank you very much. Thank you. Okay, so where's Kathy Akins? Here, they handed me the
North Broward, Your Honor, she's approaching.
sleeping on a bus bench, possession of an alcoholic beverage.
Release.
Hi, Miss Akins, how are you?
That's okay.
Well, Miss Akins, how long have you been in the jail now? How many days? Do you know?
She was arrested,
Five.
oh, sorry, Judge. It looks like she was arrested on the 15th.
Okay, so, Miss Akins, how come you haven't bonded out of jail yet?
It might have been,
Because they took my money.
Okay. Do you have family here in town?
Yeah,
You don't have any family?
yeah.
You do?
Your
Uh-huh.
Honor, if I may, as a friend of the court.
Go ahead, go ahead.
When Miss Akins was first arrested, she had a capias on another municipal ordinance, and that's probably why it wasn't resolved. But it's showing that her sentence was complete. This is the only thing holding her now.
Miss Akins, do you have somewhere to go when you leave jail? Do you have somewhere to stay?
Yeah.
Who are you gonna stay with?
I can stay with my, mom.
Right. All right. Well, I'm a little bit worried about your health. Are you going to see anyone? Are you going to any programs or anything?
No.
No? All right. All right. Well, would you like to resolve your case today? It's drinking in public. If you want to plead no contest, I'll just,
I want, bitch, I ain't even get 30 days, but they sent it though. But I ain't get 30 days for the court date.
okay, but
Just had happened.
I think she might be talking about the capias.
would you like to just plead no contest and get out of jail today?
Yes, sir.
All right. And just let me ask you, do you understand that if you plead no contest, your case is over with? We're not going to have a trial. You're not going to have your day in court. You're not going to have the opportunity to see or hear any of the witnesses or evidence against you. You're not going to have the opportunity to bring in your own witnesses or your own evidence into court. That's because the case is wrapped up. It's over with right now. And that's going to be the end of it. Is that how you want to handle it?
Yes, sir.
Okay. Ma'am, how do you plead to drinking alcohol in public?
Yeah, sir.
Okay, I'm going to withhold adjudication, assess the minimal court cost, and I give her 6 months to pay. All right, I wish you the best, all right, Miss Akins? Oh, one other thing, Miss Akins, I'm going to order you're not allowed to consume any alcohol for 90 days. Do you understand that?
Oh, okay.
All right, ma'am, thank you.
All right.
There you go. Oh, I got to give that police report back over here. Put this back over. There you go. Okay. How about Oscar Lewis?
Mr. Oscar Lewis is here present, Judge. If I can give you background information, he's been in custody since the 11th of August. I believe he was on probation. His sentence has completed at this time. He wants to know if Your Honor would consider resolving his case.
Well, does he have, what sentence what was the charge he just resolved?
Let me ask. What was
The violation
I
of
think it was,
the underlining charge on the BOP?
They gave me a one for that had 87 days in
No, what was the charge that you were on probation for?
resistance.
A resisting, Judge.
Do you live locally here in town, sir?
sir, indeed, sir.
And, all right, state,
Your Honor, just so you know, he pled out the VOP and the resisting without violence before Judge Gottlieb to 120 days, credit for 87. He's had 270-day jail sentences for burglaries. Frankly, I have no problem if the
you want to
court wants
plead,
resolve
do you want to plead this out today, possession of cannabis and resisting arrest?
Yes, sir, indeed.
Okay, let me ask you a few questions. Do you understand when you plead no contest, your case is over with today? You're not going to have a trial. You're not going to have your day in court. You want to have the opportunity to see or hear any of the witnesses or evidence against you. You're not going to be able to come to court and bring your own witnesses, your own evidence. You're not going to have the opportunity to testify and tell your side of the story or remain silent if you so choose. That's because the case is over with. It's wrapped up right now. Is that understood?
Yes, sir, indeed.
Okay, how do you plead to cannabis and resisting arrest?
No contest.
I'll withhold on both. I'll waive on count 2, just assess the court costs on count 1, all right?
Thank you, Judge.
Judge,
Yep, good luck.
Judge.
Yeah, go ahead.
Before we go into the next case,
Sure.
if you could hit the door lock mechanism, I just don't want to take a chance of Mr. Fazone coming by and thinking because the door is locked. Thanks.
Jose Garcia.
Mr. Garcia, come on up, please. Judge, he's here before you on a trespass. He has a $25 bond. He's been in 5 days. As you can see, he can't afford a post bond.
Okay.
He wants to inquire if Your Honor would consider resolving his case today for time served.
Okay. Let me ask you, Mr. Garcia, how come you haven't made bond yet?
Yes, sir.
At the moment, I can't afford it. But
Okay.
looking for work right now and so forth.
How long have you lived down here in South Florida?
16 years.
Do you have family down here?
Yes.
I hope this guy made the doc.
Okay.
What was his name again? Well, I gotta make sure they put him on.
Just give me a moment.
Yeah, he's here. We'll Judge will call next. See what I did? Yeah, this was, and just,
I put it in.
yeah, the report's there on Odyssey.
Let me just look here real quick. Okay, let me get to the next page. Right here. LifeNet, Lauderhill. Under the influence of alcohol. Okay, let me look. Drunk causing disturbance, disrupting the operation of the business. Defendant was told by the business to vacate.
This is the place he got transferred from.
He refused to leave. All right. Let me just hold on one moment. All right. Well, State, how do you feel about this if he resolves it?
Yeah, I'm fine. I mean, it's just, things have to be pretty bad when LifeNet, whose whole function is to feed hungry families and children, says you can't come around here. But that being said, he's been in a few days, so.
I have an idea that if he had not been consuming alcohol, he'd probably been welcome, but. I
Oh,
think
well,
that-
and his behavior wouldn't have been
Right.
the same, I'm sure.
Okay,
So, yeah.
Mr. Garcia, would you like to resolve your case, sir?
Yes, Judge.
Mr. Garcia, I'm going to ask you not to return to LifeNet. It's probably a good idea that you seek some help for alcohol. You know, you can go to AA and they don't even charge you. All right? All right, so are you interested in pleading no contest to trespassing?
Yes, Judge.
All right, do you understand you're not going to have a trial? You're not going to have your day in court. The case will be wrapped up today. You're not going to have the opportunity to see or hear any of the witnesses or testimony or evidence against you. You're not going to be able to bring in your own evidence, your own witnesses to court, to a trial. You're not going to be able to testify or remain silent if you choose. The case is wrapped up. It's over with today. Is that clear?
Yes, Judge.
Okay, how do you plead to trespassing?
No contest.
I'm going to withhold adjudication, assess the minimal court costs, give the gentleman 6 months to pay. Thank you, sir. Don't return to LifeNet. Not allowed to go back there.
Your Honor, could we call a case out of turn, please?
Sure.
Mark Tynes, I think is he in Conti?
Conti, Your Honor.
Mark, what is it?
Tynes, he's on page 4.
Got it.
Conti.
Mark Tynes, page 4, right here.
Yeah, this case was actually reset from yesterday, Judge.
Okay, Mark Tynes. Hey, where is he? Conti?
Yes.
Here you go. How you doing, Mr. Tynes?
All right, how are you?
Good. You've got somebody here on your behalf, I believe. What's your name, ma'am?
He named me Bestman, Your Honor.
How do you know this gentleman?
I represent him, Your Honor.
Oh, you're with what organization? Oh, you're an
No.
attorney?
Yes, Your Honor.
Oh, I thought you were from like an alcohol. Sometimes, I haven't done this in a long time. Sometimes people come in from alcohol treatment centers and stuff like that.
Oh, no, Your Honor.
Okay, I'm sorry.
No, it's
Okay, so what would you like to do on Mr. Tynes?
he's
No, please.
no, but he's going to be resolving today, Your Honor.
Okay,
Your Honor, just basically, Mr. Tynes was being held on, well, originally was being held on multiple other felony charges. He resolved them and was state sentenced. We were going to resolve it yesterday, but counsel wanted to have an opportunity to speak to Mr. Tynes because one of the counts is a DWLS. The state's offers an adjudication time served. She just wanted to make sure, she went over all his, all the potential consequences and options with him before taking the plea.
ma'am, oh, go ahead.
I'm showing DWLS.
He's got, count 1 is no driver's
the
license.
state-
Count 3 is license suspended.
You know what?
habitual.
I'm sorry, there's one of each from what I can see. Yeah, there's an operating without, that's why, an operating without, a false ID, and the DWLS.
State, can you null process DWLS?
I really can't, Judge.
No? Well,
I mean,
is he
he's-
being held on something other than this?
He's already been sentenced to state, Your Honor. This is all that is keeping
Oh,
him
he's
here.
going to state prison?
Yes, Your Honor.
Oh, okay. Well, how long is he, what's his sentence up
A
there?
year and a day.
Okay. Well, I mean, if we sentence him today, it looks like he's gonna either be habitualized or it's gonna further his habitual,
Well, that's the thing, I think he already was habitualized.
He's already been habitualized.
how long into his habitualization is he? Because, do we have his driving record over there, Mr. Tynes? Oh, good. I can take a peek at this. So, it looks like he was habitualized in 2014, right? 5 years, habitual traffic offender. So,
Yeah, that's what I was thinking yesterday, because it's
this looks like
it was
this would
treated
be,
as habitual and we put it down.
Yeah.
We have broken that because
let me just look
it's
here.
the basis that he was habitualized to begin with wasn't DUI or anything like that. So they treated it as a misdemeanor, not a felony.
This would be the first license suspended in, I don't know, what do they do if you're already habitualized and you get another ticket?
My understanding is it starts the 5-year process again.
Does it?
But I think you can't, and don't quote me, because it's been a long time for me
Right.
since I think you can get you might, once the original 5 years is up, I think you might be able to apply for a hardship, but I'm not 100% sure about that.
This may extend, because from 2014, it looks like he'd be over in 2020. But if he pleads this out in 2017, I'm not sure, but this may throw it to 2023.
Yes, Your Honor. I mean, he's already been a magistrate once. I would still argue there was even no probable cause for this charge.
Okay,
Yeah,
well, I mean, if you want me to just find probable cause and let it go to his division and set it for trial or work with the state more and see if they'll drop the charge, I can't drop the charge. I'm just trying to tell you the ramifications that I see. But if this is, something that you think you need to talk to the state about, you want to just have this set for, his division next week, plead it out there, maybe you can work something out, because I'd hate to see him get out of prison and not have a driver's license,
yes, Your Honor.
No, I would like to handle it.
Well, if it means 4 or 5 more days and your attorney can work out some deal where you're not gonna lose your license for an extended period of time, for 4 or 5.
okay.
Well,
It's okay with me.
that's what you say now, but boy,
I'll be eligible for to get my hardship.
well, I don't know. We're all speculating because none of us are experts in this field.
And that's the thing, I want to be very clear again, because I don't know if Mr. Tynes responded to what I said. I am not sure about that. It's possible, but I'm 100% not sure about that, and I could be wrong, so I don't want him relying upon what he hears me saying.
What would you like to do? You want to, if he pleads out, he's kind of pleading out in the dark here because,
Your Honor, I can advise him on the record if he wants to plead it out over my advice. That's Mr. Tynes' option. So I understand he wants to go to state to start serving his time. However,
What is your advice? Your advice is for him not to plead it out and let you try to do something for him in the trial division?
yes, because before today, I thought it was only the no valid, which is a different story than a DWLS.
And he's really getting the double whammy. He's getting suspended license and no valid DL all in the same case, which I don't usually see a charge like that.
And frankly, his attorney may be able to work out something with the division prosecutor. Unfortunately, I can't because I just don't know anything about the case. I'm just not really in a position to.
Okay. You know what? I'm not going to accept it today. I'm not going to work it out today. I'm going to let it go to the division. All right?
Yes, Your Honor.
Hold on. Can I see your sidebar, ma'am?
See who's got his case.
So I don't want you to take any kind of slight to it. No, I didn't mean it, and okay? So, I'm sure you're a fine attorney, but I'm not in a criminal loop right now, because I've been up in our satellite, so I'm not familiar with all the native cases over here. So, there you go. Okay, I'm just setting it to the division, all right? Blame it on me. I'm the bad guy.
Ma'am.
Tell her to come on down here. Oh, that's right. Okay, do you want a copy of his driving record?
Yes, Your Honor.
Okay. Here you go, come on up. Can we set that on a violation probation,
It's-
hearing doc? what-
It's in, and I was going to say, it's before Judge Lerner Wright, an MT.
Can we set it on Lerner Ren's docket next week? Yeah, just, it's quicker maybe if I set it than you set it. So he's, yeah, all right. Thank you, sir, Mr. Times, thank you. Okay. Well, thank you for being here today, and thank your attorney for standing up for you, all right? She's doing a good job for you, sir. All right. Sir, do you have a case on the docket? No, Your Honor. Okay, got it. Mr. Fasone, when you're ready to go, you just let me know, all right?
If it was my case, I'd be well with it 100%.
Have a good weekend. Bye-bye.
Does anybody here get cell phone coverage?
Nobody does. Or
Out the hall, out the door,
Yeah.
out by the escalator.
you
yes,
have,
you'll
yeah,
get
if you
it.
go outside and walk around
Walk around
in
with
circles,
your
you
phone
might
like
catch
this.
something eventually.
Do anything
Well, I was gonna say. I don't want to say anything. No. No, why not wait till the building's built before you start negotiating?
We're back on the record, and I'll go down the docket to the next one here. Okay, let's see, Gabriel Anderson.
Mr. Anderson's here, approaching Judge at Maine.
Got it.
Good afternoon, Your Honor.
Good afternoon, Mr. Anderson. Sir, resisting arrest and disorderly intoxication. Tell me, what is he being held on anything else?
I'm checking that.
No, Your Honor, this is the only thing holding him. I know he's been in custody since the 21st, as reading the PC affidavit, probably, there was allegedly a little alcohol involved. Hold on, Mr. Anderson, I'm talking for you. Judge, but I know from what he's explained to me, he wants to resolve the case. He does have one job that on Saturdays he does, I believe it's with the labor pool. He says if he gets out today, he can have work at least tomorrow, and that's going to help him get back on his feet, Judge.
Your Honor, and I just reviewing the PC, I see now why it wasn't resolved at the first appearance. And it has more to do with the allegations of, apparently he threatened bodily harm to CVS employees,
Right.
then tried to punch a clerk at a Valero gas station.
Judge, and I understand the PC report, and like I said, I believe maybe because of the allegation there was alcohol involved, at this time he's had 5 days to go ahead and, get back on his feet. Think clearly, he has no problem as far as abiding by any sort of order, no return to either premises, either CVS or any of in that area. Judge, he just.
State, does he have any priors?
Yes.
What does he have?
He was just literally about 1 month prior to this arrest, municipal ordinance.
For what?
I guess drinking in public.
Okay.
July 13th, public consumption.
I'm going to let this go to his division. All right, sir, thank you. I think maybe some alcohol treatment is in line. Thank you. What?
Please, Your Honor. Please.
Thank you,
Gabriel
sir.
Anderson.
Thank you. May I see Kenneth Phillips?
Conti, Your Honor.
There we go. Okay, hey, are you Mr. Kenneth Phillips?
Yes, Your Honor.
Hey, how you doing today, sir?
I'm doing all right, Your Honor.
I'm doing great. Okay, let's see what we're doing here. Let me just look at the docket, get the case number here.
Yeah, Your Honor, it would appear to me the two biggest issues here, one is that I would ask that it not be resolved because it looks like there's restitution issues.
Right.
Two, as far as RORing or anything like that, there was a no victim contact order, and I'm showing that they're in a relationship and both reside at the same address.
Right. Okay.
So the concern obviously would be where would any notice be sent to?
Looks like he has a pretty long criminal record. Okay, let's look here. Break rear windshields belonging to the victim. They allegedly admitted it. It says right here. Let's look on the second page.
There's nothing really there.
No, so rear windows, what does that run? $400 or $500 a window, maybe? So I'm not going to resolve it today, sir. I believe that you're going to owe some restitution. I'm going to let that go to the division. But the issue is tell me recent criminal record if there is any.
Okay, just one moment, Your Honor.
I may release him, but I'm not gonna work it out, because there's restitution.
His last arrest in Broward was November of 2016,
What?
and that was on actually, that was a felony offense, but it was dropped. Prior to that was June of 2016, and that was a capias on a traffic matter. Then you got to go to October 2014.
Does he have any
was it.
violence in the past?
As far as, again, this is as far as Broward County goes. No, it doesn't look like any violence.
What's his bond right now?
It is it $100? I think it's $100.
$25.
$25.
Do we know the name of the victim?
It's Tammy Miller. Yeah, and I just realized you can't see it there, Your Honor.
Right.
Because they blacked everything out. Did they black the address out also? It's showing the same address. They're showing the same address where he.
I'm not gonna take any action on it today, all right, due to the nature of the situation. Thank you, sir. You can bond out or see your division judge. How about James Holbrook?
Mr. Holbrook is here, present judge at Maine. He's approaching.
Mr. Holbrook, so you're here for possession of cannabis, paraphernalia, theft, loitering and prowling.
Yes.
State, does Mr. Holbrook, I believe Mr. Holbrook's been through here before.
Yeah, there's some,
I-
Your
I-
Honor. There.
I believe I remember Mr. Holbrook from case I had in the past through here.
I mean, there's certainly
I may
something
be
going on
wrong.
here. I don't know about that, but I'm looking. The bonds were raised to $5,000 on the theft and $1,000 on the loitering and prowling.
Okay. 17. You just-
I'm gonna have to put him in the system because there's something here that
Who raised it?
Wednesday. So it was Judge DeLuca.
Judge DeLuca did it.
Yeah.
What they need is they need a copy right here. Right up here. Right over there.
Judge, Mr. Oasis is really interested. Sorry, Mr. Holbrook is really interested in the court. Trying to help him out today. He works at a restaurant called Oasis by the Sea. He was just explaining that to me. I believe he said this is a Greek restaurant. He still believes that they're holding his job for him. He's been in custody now since the 22nd. Judge, we'd be asking you to consider resolving the case, or in the alternative, if not, we'd be asking you to consider on counts 1 and count 4 to reducing the bond from $5,000 to $100 and the fourth count from $1,000 to $100. He believes someone could potentially post this $300 bond.
Yeah.
And, Your Honor, if I could just have a moment, I can't remember the case, but I can't imagine Judge DeLuca raising the bonds to those amounts with no reason.
Mr. Holbrook, how long have you lived in South Florida, sir?
Actually, only a month and a half.
Right, so now, yeah, where were you living before that?
Houston, Texas.
All right, and what is your local address, street address?
1422 Wiley Street. It is in Hollywood, Florida. I'm not so good with the zip codes yet.
Yeah,
I
But
remember.
it's kind of an Airbnb where I pay $175 a week, Your Honor. Which
Got it.
I could still save. All my stuff's there, my job, and my father lives in Hollandale. So I'm trying to deal with this case without completely.
what is
crashing
the
my life.
address again?
For where the B&B is?
Yes,
1422 Wiley Street, Hollywood, Florida.
got it, go ahead, State.
I remember now, Your Honor. Mr. Holbrook has a warrant that was just issued last month for failure to appear in court in Texas for burglary of a vehicle.
Oh, really?
Yes.
So he's got a warrant out of Texas for burglary of a vehicle.
Houston,
He's been
Texas.
here for about a month, and he's allegedly, let me see here. Gray Mazda, he attempted to burglarize the victim's Mazda Tribute. Got it, let me just look here.
That's you.
Oh. Yeah, Your Honor. Also,
Right,
and now I remember Judge DeLuca. If you go to the second to last page of the report,
Right.
where it mentions they found checks in his wallet that were stolen from burglary. Blank checks. Or checks. I don't know if they were blank.
I'm reading from the police report. While conducting a search incident to arrest of the subject, I located a brown-colored wallet in the arrestee's back left shorts pocket. Inside of the wallet, I located a blank check. The check was a Bank of America check from okay. I then made contact with the resident via telephone and spoke with the owner of the check. Advised that his 2014 Chevrolet Silverado was broken into and his wallet was removed from under, okay, from where, okay. It was a vehicle burglary. Sir, it's alleged you just happen to have the man's blank check in your wallet from this vehicle burglary where you were suspected of committing another vehicle burglary on a Mazda. I'm going to leave your bond the way it is, sir. Thank you.
We have one last gentleman here, Judge, for the second look docket.
Okay, is that Michael McLeod?
Yes, it is, Judge.
Okay,
Mr.
come on up,
McLeod,
Mr.
come on
McLeod. Say, does he have any criminal record?
I'm checking that right now, Judge.
Judge, my understanding is he's here on a 948 hold. Also, besides the misdemeanor offense, I've advised him not to resolve this case. I'd ask you, Judge, to consider an ROR so that Dade County can pick him up. I believe he's on probation for a felony offense.
He's an out-of-state hold, right?
And he has an out-of-state hold as well.
So there's no point to ROR.
Yeah, the court's not going to take any action. Good luck, sir. Thank you. Okay.
Well, there is a point, Mr.
No, there's not. He can't
Well,
go anywhere
I'm
until the out-of-state.
I'm not going to take any action, not based on Mr. Linder, but I'm going to I'm not going to take any action. Thank you.
Now, if you come back and say, tell me George dropped this out-of-state hold, then that's something to talk about. But until then, it actually only hurts. Let's say hypothetically, it just says.
Yes, Your Honor. Sorry to appear in plain clothes.
Who do you have? Jeremy Cooper.
That's Robert Lee.
No, we have Jeremy Cooper. Let me get him out of here. So
All right.
he can leave. Hold on.
It's
Jeremy Cooper. Cooper? How you doing? Steve? Sorry.
he can be ROR. We haven't filed an information.
Mr. Cooper, I'm going to release you on your own recognizance, all right?
Thank you so much.
You're welcome. They have 30.
We do Jimmy Burke, Judge?
Arrest to file. Go ahead.
Eric, did we do Jimmy Burke?
Jimmy Burke. Jimmy Burke.
No problem, Your Honor.
Hey, Jimmy Burke, how you doing?
Your Honor, we have not yet filed information. Mr. Burke can be ROR, and Brian, you may want to stay in touch with him. I believe we're going to be declining the charges, so I guess when that happens, Mr. Reedy can update him so he doesn't have to worry.
Call
about
our
it.
office, call the public defender's office next week for an update on your case, Mr. Burke. They may not be charging you with a crime at all.
Mr. Burke, you're being released on your own recognizance on count 6 and 7. Thank you. You throw that away. I'll do it. Yeah, no problem.
I'm done, I'm out of here.
Yeah, sure, rub it in.
Thanks, Judge. Thanks, Judge.
It's good seeing you again.
Clark.
Good seeing you. How's the married life?
It's great. man.
Good.
We have a great time.
There you go.
We have a lot of fun.
There you go.
Did you already?
You're a good man, sir. You're a good man.
There you go. I always do that, so nobody writes below me, you know what I mean? It's like having a widow page on.
Jesus, where's your, are you a goldfish?
Okay.
41.55.
All right.
Yeah, makes sense.
May I
41.
see Robert Charles Lee. Mr. Lee,
Yes, sir.
I've already advised you your right to remain silent. Do you remember that?
Yes, sir.
You have an attorney, Mr. Joe Fasone here. He's a very competent attorney, shares a great reputation in our community. You should allow him to speak on your behalf, all right?
Thank you, Judge.
Yes, sir.
Thank you, Mr. Fasone. Good afternoon.
Good afternoon. Thank you for allowing me to appear in street clothes this afternoon. I read the probable cause affidavit for Mr. Lee. If we can waive formal reading of the charges.
I'm not going to say it out loud. So, but I do note that he's charged with 4 very serious crimes.
Right.
State, or which one of these, I know that
Count 2 is the punishable by life offense, Your Honor.
count 2 is the PBL.
If I may proceed.
Go ahead.
Please the court. Your Honor, on count 2, the state under Esaza v. State is going to be seeking a finding of proof evident or presumption great for first appearance purposes only, and seeking a no bond hold on count 2. Your Honor, I would ask if the court could make a determination as to that finding first, because I would like to make an argument with regards to bond on counts 1 and 3, and
Okay.
just separate the two issues.
What I ask, Your Honor, is that defer ruling on these matters until the case is assigned to the trial division. According to the probable cause affidavit, it appears to me that all of the facts that are alleged are based upon a 7-year-old's testimony.
I understand. Let's just first address procedurally how we're going to proceed. The court believes that it has a duty to adjudicate the matter today at first appearance. And if you want to seek relief in your trial division, you can do that. But today, the court's going to address whether there's probable cause on count 1, 3, and 4, and whether there's proof evident, presumption great on 2. All right? And there's a new case in the last 2 or 3 months out of the 4th DCA, Esaza. The Esaza case basically modified and clarified the cases we relied on in this court for a long time. What were the prior cases that we?
There was Brackett, there was Preston, Your Honor,
Preston.
and
Yeah, Preston, Esaza really clarified Preston a lot in this district about at first appearance, proof evident, presumption great. And so State, go ahead. You want to make your pitch on count 2, why
Yep.
you believe there's proof evident, presumption
Yeah.
great, and then I'm going to turn to Mr. Fasson to reply.
yes, and Your Honor, I don't believe that the fact that the officers were relying upon a sworn statement, forensic statement given by the alleged victim, in and of itself means that the court cannot find proof evident or presumption great. I think what the court must look at is the details that are provided. And I'm not going to go into those details. The court has reviewed the probable cause affidavit. You're familiar with them. But I think there's such great detail given in the victim's statement that it gives, I think, such a degree of credibility to the allegations that the court can find proof evident or presumption great at this time for first appearance purposes only.
If I may respond,
Yes.
certainly a 7-year-old child doesn't speak like this as to what is typed in this narrative portion of the probable cause affidavit. Certainly this has been paraphrased by the arresting officer or detectives. Short of actually listening to the videotape testimony of the 7-year-old child, I doubt that all this detail was provided without, I would imagine, a lot of coaching and suggestion. And from what I've gathered in my short involvement in this case, speaking with Mr. Lee's girlfriend and his sister, this child has changed her accounts on several occasions. Number 2, her own mother, her name is Tiffany, even stated to Mr. Lee, his girlfriend, his sister, his mother, saying, quote unquote, "Would you believe what this lion B," end quote, said, end quote, about allegations. So, I think her own mother might even doubt the veracity of the child's testimony. So we have a credibility issue, obviously, and I would object to Your Honor making a finding of proof evident presumption great.
And Your Honor, and there was just one other thing I meant to state, and I think it is relevant with regard to the strength of the evidence. It should be noted, Your Honor, that the forensic interview of the victim was both audio and video recorded.
Got it? Okay. Now, the court today has read the probable cause affidavit. The court notes that for a child of the age which is listed, the court notes that the child conveyed certain specific anatomical and perhaps biological experiences. And I'm not going to get into the, over the airwaves here, I'm not going to get into what I mean, but I think it's clear from reading the probable cause affidavit that a child that age recited certain experiences which this court does not feel the child would know about unless the child had had those experiences. And as the child recounted its alleged contact with this defendant. And the court is taken and understands the detail in which the child testified. The court, taking the totality of the circumstances, believes there is proof evident presumption great as to count 2. The defendant will be held without bond until further order of the court as to count 2. Count 1, 3, and 4 are bondable offenses. Now, State.
Your Honor, may I approach?
Go ahead.
And I'm providing the court, and I've shown Mr. Fazzone. Mr. Fazzone has had an opportunity to review this report.
Okay, what is this?
Let me just go back to the mic.
Okay.
Your Honor, it is made a reference in the report to a juvenile prior, and that was out of the state of Illinois. What I have provided the court.
State of Illinois. What is that, Platte or Platte County?
Your Honor, I would object to the state producing this information. This is not a certified conviction. It's a juvenile offense that occurred when Mr. Lee, I think, was 17 years old. He pled, according to that report, to a lesser offense. We don't have fingerprints. We don't have a certified conviction. What you're looking at is hearsay and ask that Your Honor not consider.
Okay, well, at this point, the court is beyond the count 2 where the court's found proof evident presumption great. The court has found probable causes is finding probable causes to count 1, 3, and 4. At this stage, the court is merely taking information in for purposes of setting bond or release conditions. I don't believe the court is required to accept only those things that are under oath, or the court does look at this and does find there's a level of confidence when the court looks at this. It looks like it's an official document. It looks like it's from, I believe, Platte or Pratt County from Illinois. It's signed by a deputy sheriff. It looks like it's signed by the defendant. It's dated. So for the purposes of determining or setting bond or release conditions, the court will, by the way, it's P-I-A-T-T County, and it has an officer narrative attached to it, the police report 98-000105. It looks like a police report. So, and it's signed by Robert Manant, Chief Deputy. Manant, M-A-N-I-N-T. If I could just quickly review it.
And Your Honor, before we, if I could just add one thing, because I just want to make a record of this in case there is some type of appellate review of this hearing. Your Honor, my understanding of the rules of criminal procedure also is that for this first appearance hearing, and the Supreme Court and the rules are quite clear, that the rules of evidence need not be followed stringently 100%, based on the very reason that every report the court considers in determining probable cause essentially is hearsay, since no one is here to testify to those reports.
What I'm trying to avoid, Your Honor, you might appreciate being a defense attorney in the past. I don't want there to be a spillover effect, if you will, from count 2 onto these other counts, and now you're seeing this other piece of information that you mentioned his name was signed. That was a Miranda waiver, it seems. but he's
Well,
a juvenile.
let me just
That's
say
all it
that,
is.
that I'm looking at this, you're right, it is Miranda, sorry. But I am looking at a police report, and I am looking at other documents from the Piatt County Sheriff's Department. One is a police report, which looks like it was created back in 1998, and it does look legitimate. Like I say, this is not concerning count two. The court did not look at this report before determining proof evident presumption greatest to count two. This is merely the court trying to determine bond or release conditions for 1, 3, and 4, and the court is just looking at a police report. So I'm going to consider the police report that the state's given me from Piatt County Sheriff's Department. It's called a juvenile sheet. That's what it said. And then it has a report attached there too. I've already said the name, the police report number. And what I'm going to do is I'm going to go ahead and incorporate this police report as part of the court file just for the purposes of first appearance. So if there is any kind of appellate issue, that the appellate court sees what the court has reviewed. Okay.
And, okay,
So, State, I've read this.
Your Honor,
It does appear that the defendant has been engaged in similar activity in the past regarding females of the same age area.
Your Honor,
No, that's not
no.
correct, Your Honor.
Young females under the age of 18.
At the time, Mr. Lee was a juvenile, and the age of the victim in that case, I believe, was also in high school.
no, Your Honor, if I may, and they actually have it. The alleged victim, well, not the victim in that case was his stepsister, either 10 or 11. 11.
Thank you.
Your Honor, if I may proceed,
Go ahead.
the state is going to be requesting bonds in the amount on count 1 and count 3 at $500,000 each. My reasoning, Your Honor, is I can't have a greater concern for the safety of the community, or in particularly minors in this community, with respect to Mr. Lee. Your Honor, I can also advise the court he's been to prison out of the state of Illinois for burglary of a home with burglary dwelling. He was sentenced to 6 years. He was also convicted of failing to maintain his address, I believe connected to, he was at one time registered as a result of the offense, the juvenile offense, Your Honor, because of later Supreme Court rulings that had to do with juveniles that were registered. I don't believe he is no longer registered.
So
But-
at one point, he was a registered offender.
Your
Is that
Honor,
correct?
yes, and you familiarized yourself with the allegations, or
Right.
not allegations, but the facts of the case out of Illinois. Your Honor, it's mentioned in the report, and I verified this. The 2006 Broward arrest, while he pled out to child abuse, he was originally arrested for sexual conduct with a minor, and I think that is extremely important when considering bond in this matter, because it wasn't a matter of he punched or committed a violent act, or they're all violent acts, but there was a sexual nature to the allegations that he
Right.
pled out to. This is a third allegation that we're aware of, Your Honor. Quite frankly, to put it simply, Mr. Lee is a predator.
Right. Okay, any
Object
response?
to the characterization.
I understand. Any response about this defendant's ability to post bond, his ties to the community? Anything you'd like to present?
Your Honor, certainly a $500,000 bond is like no bond at all. He has maintained steady employment in the community. He's an electrician. He has a family. He has a fiance and a child of 3 years old. They live together with the girlfriend's, the fiance's son as well. Brandon and Braden, I believe are the names. Excuse me, Cameron. Apologize. 2 children that he provides support for, as well as his fiance. They live in West Park together, and he has a mom that lives here, a sister that lives here. He has ties to the community, and I'd ask that Your Honor set a bond at the standard schedule for the counts 1,
Understand.
3, and 4.
Yes, sir. All right. This court, sir, determines and has concluded that you represent an extreme danger to the community. You've been convicted as a juvenile of a crime regarding sex in the past. The state of Illinois declared you one time a predator. That has since either expired or come off your record. You've been convicted and gone to prison in the state of Illinois for burglary of a dwelling. And in Broward, there was a sex case with a minor that you eventually resolved as child abuse. So you have a track record of abusing young girls. The court believes in this case the evidence is strong against you, and the court believes that you're on the street. Every young girl in the community is in danger. The court is very concerned, and I've reviewed all your prior report out of Illinois. I've reviewed the facts of the case, and the court believes appropriate bonds on count 1, 3, and 4 are $750,000 per count. Count 2, you'll be held without bond. This court will order that you have no contact directly or indirectly with the alleged victim. Alpha Charlie, that's AC. No contact with the victim's mother, alleged victim's mother, and that is TG, that's Tango Golf. No direct or indirect contact with either person, and
I'm sorry, only because it mentions that there was another child that might have been left. I'm just asking in an abundance of caution that no victim contact, obviously, but no contact with any of the victim's family members.
no family member contact with AC or TG, sir. Thank you.
Oh, Your Honor, I'm sorry. I would also ask for no contact with minors. It should at some point be
No contact with any minors if you make bond, and if he does make bond, I'm going to order a pretrial release GPS monitor, level 1 lockdown. No access to. You're not allowed to go into a park. You're not allowed to go to any kind of schools, any children's centers, and you're not allowed to have any private contact with any female under the age of 18 if you eventually make bond. Thank you. Thank you, Mr. Fasson.
Thank you.
There you go.
Your Honor.
That's how I read it. Okay. There you go. Anything else? Is that a wrap?
Yes, sure.
That's it. Thank you very much, everyone. It was good coming back down here. Mr. Fasson, it's always a pleasure seeing you. Great respect. You always do a good job. Mr. Linder, our great clerk over here, I haven't worked with in a while, always does a great job. Our people from pretrial, it's good to see both of you. All right, and we are out, and everybody have a great weekend. All right, look who we have back here, Ms. Springer. Okay, thank you, Judge Malika. We're out from first appearance.
Judge, you going to be here for a few minutes?
Yeah.
I'll be back.
Okay, well, we're only out if the court can figure out how to turn this off. Power down. Power down and exit.